I wanted to welcome you all here. I'm Gary Simson, the Dean of the Case Western Reserve School of Law. I thank all of you in the audience for coming, and those of you who will be hearing the debate or hearing it right now as it's broadcast. Like this conference, the debate is sponsored by the law school's Frederick Cox International Law Center, which was established in 1991 through an endowment from the Gunn Foundation under the leadership of its director, Professor Michael Scharf, and the associate director, Jackie Lipton. The center is clearly one of the jewels of the law school, and the conference today, I think, is typical of the center's cutting-edge and intellectually provocative focus. The conference comes almost exactly a year since Saddam Hussein and 7 of his cohorts went on trial before the Iraqi High Tribunal. They were charged with destroying an Iraqi town and torturing and murdering its Shiite inhabitants. The proceedings, which were televised around the world, were anything but orderly, including events such as assassinations of defense counsel and resignation of judges. The tribunal is going to reconvene on October 16th for a judge's review of the process, and at that point, prior to verdict, it's quite possible some witnesses may be recalled. The debate that follows will look at the fairness of the trial. Did it comport with international standards of due process? 2 of the people seated here will argue that it was unfair. Professor Kevin John Heller, a member of the law faculty of the University of Auckland in New Zealand, will be up first. His life, as well as his teaching and writing, are profoundly international. He has a J.D. from Stanford, several years of criminal defense practice in Los Angeles, and then headed off to New Zealand. Kenneth Roth will speak next. He is the executive director since 1993 of Human Rights Watch, which, as you know, performs extraordinarily important functions as far as investigating, reporting on, and attempting to reduce human rights violations around the world. He's a graduate of Yale Law School, and Human Rights Watch has grown enormously in stature and scope under his leadership. The 2 of the people seated here who will argue the trial was unfair are Professor Michael Scharf of this law school, who among his many contributions to international law was a member of the team of experts who trained the judges and prosecutors of the tribunal that tried Saddam Hussein. With Gregory McNeil, he co-authored the first book that has appeared on the trial. He's a Duke Law graduate, and he has been an invaluable member of this faculty since coming here in 2002. Last, Professor Michael Newton of the Vanderbilt Law faculty will speak. He's a graduate of the University of Virginia Law School. He practiced law in the military for some time. He served as a senior advisor to the United States Ambassador at Large for war crimes issues. The debate will go as follows. First, Professor Heller and then Mr. Roth will each get 12 minutes to argue why the trial wasn't fair. Then Professors Scharf and Newton will each get 12 minutes to argue why it was fair. In the same sequence, then, each participant will get 2 minutes to respond to arguments from the other side. For a number of reasons, it's important that all the speakers adhere to the time limits. There is the student in the front row will hold up time cards to remind them of the limits as they approach, and using whatever skills I acquired as a faculty member, I'm going to cut in as politely and firmly as possible when their time is up. So let me begin with the first speaker, Professor Heller.
Well, first, of course, thank you to Michael and to everyone else for having me here. I want to begin my presentation by offering kind of 3 basic assumptions that frame at least my approach to this issue. First is that there's no question in my mind that Saddam Hussein is guilty of most, if not all, of the charges against him. I also believe, however, that Saddam would have been found guilty after a perfectly fair trial, that you didn't need to cut the corners that I will discuss in order to convict him. And that third, and perhaps even most important, the fact that Saddam is guilty of most, if not all, of the charges against him in no way justifies depriving him of the right, to quote the Rome Statute, of a fair and regular trial, affording the legal guarantees required by international law. Now, I want to focus on 5 critical flaws with the IHT's procedures, flaws that I believe undermine the fairness of the Dujail trial, and perhaps even more important, kind of given the nature of this get-together, will continue to undermine the fairness of any trial that is held. So I want to focus really on the statutory law as opposed to simply the conduct of the trial itself. And my point is extremely, hopefully, constructive and not simply critical. Just as I feel about international criminal law generally, if there wasn't so much promise, if there wasn't so much strength, it really wouldn't be very much point in offering criticisms. So, that said, the first flaw that I want to focus on is the burden of proof. The IHT, I believe, uses an inadequate burden of proof. According to the Code of Criminal Procedure, the tribunal could convict, quote, based on the extent to which it is satisfied by the evidence presented during any stage of the inquiry or the hearing. Now, there's always difficult translation issues. It's been suggested that instead of satisfied, it should be conviction. But as I will try to explain, even if that's the case, it is still, at least under international standards, an inadequate burden of proof. Every tribunal since the NMT, since the Control Council trials, has used proof beyond a reasonable doubt. The Human Rights Committee has continually emphasized that proof beyond a reasonable doubt is necessary to give effect to the presumption of innocence. And I think it's important, despite the attention that the issue has gotten from Amnesty International, Human Rights Watch, etc., to focus on it here because Professor Scharf has claimed on a number of occasions that, in fact, the standard that the IHT uses isn't inadequate. And I'm going to quote him. He says, the traditional standard which civil law judicial systems, like France and Holland, employ, and a phrase that is functionally equivalent to the American beyond reasonable doubt standard, again describing the satisfaction standard. And with all due respect to Professor Scharf, I don't believe that's correct. The only civil law system that uses even a remotely similar standard is, in fact, the Netherlands. It uses a, quote, gained the conviction standard. That standard is arguably more stringent, certainly, than a satisfied standard, if that's the correct interpretation or translation. But even that standard has been criticized within the civil law community as not being stringent enough. France uses an innermost conviction or an intimate conviction standard that the European Court of Human Rights has said is, in fact, equivalent to beyond a reasonable doubt. Italy uses a definitive conviction standard. Germany uses a leaves no reasonable doubt standard. Spain uses a reasonable doubt standard. Russia uses a reasonable doubt standard. Greece uses a reasonable doubt standard. Venezuela uses a reasonable doubt standard. So really, by any civil law standard, the IHT's satisfaction standard or simple convinced standard is inadequate. And I think that's a very important point. As Professor Scharf continually dismisses the IHT's flaws by analogizing to the harmless error doctrine that we all know is such an integral part of American criminal law. And if we extend that analogy further, in the U.S., an inadequate burden of proof is never harmless error. It is per se structural error requiring reversal of a defendant's conviction, even if that defendant never objects. So this is an extremely critical structural point about the burden of proof that the IHT uses. The second flaw, and we've heard a lot about it so far, is the IHT's lack of independence from the Iraqi government. I won't bore you with the same details that we've heard earlier. I just want to, again, kind of root it in the text of the statute. Article 4 of the IHT statute gives the Iraqi government complete and unreviewable discretion to decide which judges remain and which do not remain on the tribunal. It says, the Presidency Council, in accordance with a proposal from the Council of Ministers, shall have the right to transfer judges and public prosecutors from the court to the Higher Judicial Council for any reason. And we've seen, and it's been discussed earlier, the consequences of that. 2 judges removed at the Dujail trial. Most recently, a specific invocation of Article 4 to remove the on-fall judge. Now, nobody wants a biased tribunal, whether that tribunal is for or against Saddam. But what's critically important to note is that there are provisions in the IHT statute, in Iraqi law, for removing a biased judge. Rule 8 of the Rules of Procedure, passed by the IHT, allows for either party to make a motion to remove a biased judge and requires the decision to be made on that motion within 3 days. Well, what's the difference between Article 4 and Rule 8? Well, Rule 8 is an internal process. It is the judiciary itself deciding whether a judge is biased, whereas Article 4 is the Iraqi government, the executive determining for the judiciary who will be on the tribunal and who will not. And that is where the fundamental and so necessary independence of the IHT breaks down. Third, and this one I think can't be emphasized enough, the tribunal does not confirm an indictment until the middle of a trial, after the close of the prosecutor's case in chief. One of the provisions of the Iraqi Code of Criminal Procedure describes the initial phase of the trial as hearing the testimony of the complaining witness, the prosecutor's evidence, and then you have this paragraph 181 that provides, quote, if it appears to the court after the aforementioned steps have been taken that the evidence indicates that the defendant has committed the offense being considered, then he is charged as appropriate. The charge is read to him and clarified, and he is asked to enter a plea. There are three really critical problems with this procedure, and it's worth noting that this procedure deviates fundamentally from any of the international tribunals. First, it means that the investigative judge's decision to indict a defendant is never reviewed by an independent judicial body prior to trial, obviously significantly increasing the likelihood of an innocent defendant being convicted. The Dujail trial is a perfect case in point. Professor Scharf has himself noted that the prosecutor asked the tribunal not to convict one of the defendants in his closing argument. Well, we can certainly hope that the tribunal heeds the prosecutor. There's certainly no guarantee that it will. Even if it doesn't, how fair really is it to subject an innocent defendant to a 9-month ordeal in order to ultimately claim his innocence, largely because there is no procedure in the IHT statute for pretrial confirmation of the indictment, as is very standard at the international tribunals. Second, mid-trial confirmation is fundamentally, fairly obviously, inconsistent with the defendant's right to be informed, quote, promptly of the charges against him. Now, there is a provision in the statute that requires the tribunal to read the indictment to the defendant prior to trial. But, of course, that indictment isn't the final indictment. The final indictment will be issued mid-trial. The tribunal remains free to add or change charges against the defendant over the course of the trial, and the tribunal is under no obligation to inform the defendant that it is going to add charges to the indictment. And, in fact, that's exactly what happened at the Dujail trial. The, quote, clarified May 2006 indictment added new charges against all 7 defendants, including compulsory concealment of people, kidnapping, and the kind of wonderful catch-all other similar actions against humanity. And this leads, of course, to the final problem with mid-trial confirmation, which is it blatantly violates the defendant's right to have adequate time and facilities to prepare a defense. You cannot defend yourself against charges that will change mid-trial after your appointed counsel or your hired counsel has cross-examined the prosecutor's witnesses. That's the third. The fourth is the IHT's provisions for the disclosure of exculpatory information to the defense or exculpatory evidence. This right is obviously fundamental to a fair trial. The right of the defendant to receive exculpatory information is the critical mechanism that prevents the conviction of innocent defendants. And it's particularly important in a non-adversarial system like Iraq's, where so much, as we've heard, of the investigation is conducted by the judge and not by a defense attorney. Rule 42 of the IHT statute itself confirms the right of the defendant to receive exculpatory information. There is, however, a very critical exception to Rule 42 contained in Rule 43. And the exception really does swallow the rule whole, to invoke the old expression. Rule 43 specifically exempts from disclosure all information that is provided confidentially to the tribunal, even if it is exculpatory. Here's the rule. If the tribunal is in possession of information which was provided to it on a confidential basis, and which has been used solely for the purpose of generating new evidence, that initial information and its origin, notwithstanding Rule 42, and that's the exculpatory evidence provision, shall not be disclosed by the tribunal without the consent of the person or entity providing the initial information. Rule 43, in other words, specifically provides that the tribunal's obligation to protect confidential information trumps the defendant's right to obtain exculpatory information. That's a very, very critical limitation and a potentially vast one, because it clearly embraces, at a minimum, all 3 of the categories of information that Rule 40 allows the tribunal to maintain confidentially. Information relevant to an ongoing investigation, national security information, and kind of the most broad, information whose disclosure would be, quote, otherwise inimical to the public interest. Did Rule 43 undermine the fundamental fairness of the Dujail trial? I have absolutely no idea. And that really is the problem with the rule. We have no way of knowing what information wasn't disclosed to the defense. There is no procedure that allows the defense to challenge the nondisclosure of information that's protected under Rule 43. I'm running out of time. I was going to talk a little bit about appointed counsel, but since we've seen the skirmishing between the various parties, I'll leave that to them. I will simply say that if you look at the provision for appointed counsel, it is simply the defense office must appoint, quote, highly qualified criminal defense attorneys. They could certainly appoint adequate ones under that standard, but it is worth noting that that standard contrasts with, say, the ICTY, which specifically requires experience in international criminal law, international humanitarian law, or international human rights law, and requires at least 7 years of experience. And I think a specific standard like that would lead to far more fundamental fairness for defendants, given that the ICTY, or excuse me, the IHT, it is applying in every facet international criminal law, the definition of crimes, the modes of participation, the defenses, sentencing considerations. These are all made with reference to international criminal law. So to not specifically require defense counsel to have demonstrated capacity in that body of law, I think fundamentally undermines the defendant's right to a fair trial. And then again, just to conclude, there is no doubt in my mind that Saddam is guilty. There's also no doubt in my mind that he would have been found guilty after a fair trial. His guilt, however, cannot be used to justify ignoring the countless ways in which the IHT violated his right to a fair trial. Because the more you accept that you can get away with simply because a defendant is guilty, well, the closer you do get to the kind of trial that I think we would all like to avoid. Thank you.
Next is Mr. Roth.
Thank you. Good afternoon, everyone. Let me begin by expressing my gratitude to Michael Scharf and to Case for organizing this very important conference. I also want to say I'm happy to be back here in Cleveland. There was once a time in my life when I had spent 3/4 of my life here. And then when leaving on age 4, it left me with very fond memories. Now, since then, and particularly since I was at Human Rights Watch, I've spent a huge amount of my time, probably more than anyone else, looking at the crimes of Saddam Hussein and trying to bring him to justice. And frankly, it saddens me that we're here having to talk about the fairness of the trial rather than focusing on his crimes. I understand the natural preference to have national justice if possible, but if possible is the key word. And we should have recognized that in this situation, it would not be possible without a much greater international dimension to the trial than has taken place. And what we saw instead was ideology over pragmatism, a hatred for international tribunals taking precedence over the practicalities needed to ensure a fair trial that might have let us focus on Saddam's actual crimes. Now, I say this based on Human Rights Watch's extensive observations of the trial. We have seen roughly 80% of the trial days during the Dujail trial. We didn't watch TV. We didn't read about it in the press. We were there. Most of that, we had a native Arabic speaker observing, so there was no translation problem. And most important, we looked at the dossier. We looked at the documents that were actually submitted, which are, in this case, critical. That on-the-ground observation has made clear to us serious procedural shortcomings in this trial. And these shortcomings were not simply due to the disruption of the defense counsel, serious as it was. These were due to the way the trial was conducted. Much of this, frankly, comes from the lack of understanding of what a fair trial is on the part of many of the participants in the Iraqi court. And that is not surprising, given that we have still not found a defense attorney or lawyer who remembered a trial that lasted more than a day and a half before this trial started. In fact, as my colleague has mentioned earlier today, the typical trial to this day lasts 15 to 30 minutes. And that will often lead to, a 20, 30-year imprisonment. So this is not a system with a well-developed sense of due process. Let's see how that manifested itself. And I want to highlight 5 serious procedural errors in the course of the trial. The first, Kevin just referred to, has to do with the lack of notice because there was never a real indictment until well into the trial. The initial indictment basically said, you're guilty of crimes against humanity because of, people who were killed around Dujail. Nothing about even the theory of liability. Was this command responsibility? Was it aiding and abetting? Were you a principal? No detail at all. And a basic element of due process is that you're given the facts so that you can prepare your defense. Now, yes, halfway through the trial, they spelled it out a little bit. But that was after many witnesses had already testified. after the opportunity to cross-examine them on this theory of liability had been lost. That is not the kind of notice that is required in order to give people a fair fighting chance to defend themselves. Second, there was extremely late disclosure of much of the key documentary evidence. The court rules themselves require 45 days notice. That's important so you can read the documents, figure out what's in them, their significance, so you can authenticate them, challenge them if appropriate. It didn't happen. 40 documents were produced smack in the middle of the trial, documents that were not in the original dossier, and so the defense attorneys had no access to them before that. In addition, 3 critical audio recordings were disclosed, again, right in the middle of the trial. These were recordings purporting to record conversations between Saddam and some of his co-accused about Dujail. The defense objected. The judge let him in nonetheless. Perhaps most important for a few of the minor defendants, handwritten letters, undated, supposedly by them, were introduced in which they were writing to the Ministry of the Interior purporting to give the names of suspected Dawa party members from Dujail, many of whom were later arrested and executed. Again, smack in the middle of the prosecution's case, no 45 days notice, not exactly the kind of fair procedures that even the court's own rules called for. Third, anonymous witnesses. 26 of the 29 witnesses who testified live during the Dujail trial were what you might call constructively anonymous. That is, their name was deleted from the dossier, so there was no notice of who was going to testify until they showed up in court. And basically an hour beforehand, the name would be disclosed to the defense. Even then, all but 3 of the defendants testified behind a screen, so neither the defendant nor the defense could see their demeanor and use that important piece of evidence to cross-examine them. This was, of course, a very severe restriction on their right to confront those testifying against them. Now, we all know that there's a very clear security danger in Baghdad. Many people have been killed who have been associated with this trial. But international practice is to assess that danger case by case, witness by witness. That didn't happen with the IHT, which instead basically let the witness do whatever he wanted or she wanted. If you want to be anonymous, you're anonymous. No measuring the need against the needs of the trial. And this was the case even, say, with witnesses who were known. Someone like a former senior official who nonetheless was allowed to testify out of sight, even though everybody knew who the guy was. International courts have moved away from this kind of anonymous witnesses, largely because they were burned. One anonymous witness turned out to be lying through his teeth. Instead, they tend to use a confidentiality procedure in which the defendant and the public may not be informed, but the defense attorney is. You couldn't do that here because you couldn't trust the defense attorneys because they were only Iraqi defense attorneys. One more indication of what goes wrong when you don't allow a certain internationalization. Fourth, there was no right to confront at all 29 other witness statements that were introduced into the trial. That is, in addition to the 29 live witnesses, there were 29 pieces of paper that were read. Never explained why. No notice was given to the defense as to why this happened. You obviously can't cross-examine a written statement. When the defense challenged it or asked for the witnesses to be called, they were ignored. Not even a ruling. I mean, not an explained ruling, just a, no. And in fact, as has been mentioned, that was common. Almost all of the interlocutory challenges, motions, etc., were simply ignored or denied summarily with no written record or reason provided to date. Fifth, when it comes to the authentication of documents, which is crucial in a case that to a large degree was built around documentary evidence. I know Professor Scharf has said there was broad authentication of the documents. I'm sorry to say he's wrong here. If you look at what actually happened, only 7 of the documents were authenticated through a Ministry of Interior handwriting witness who was brought in and said, oh, yes, this is the signature. These are authentic. It was his written report that was submitted saying that. He was never cross-examined. No defense handwriting witness was ever allowed. And indeed, the defense was never given access to the original documents to even see whether it was worth challenging authentication or not. No explanation for why this extraordinary procedure was used. Those 7 documents were the best cases, the fairest cases. The rest of them, 100 or so documents, came in. No authentication whatsoever. The prosecutor wouldn't say where the documents came from. He wouldn't allow the defense to inspect the originals. There wasn't any effort really made to create a procedure in which authentication could be challenged or established. This is, of course, absolutely essential, because who knows where these documents came from? Were they made up? Were they, we just don't know. And we're just, stuck with the sort of trust me defense. Worse, if you can get worse, some of the documents were, shall we say, incomplete. Let me give you an example. The entire court transcript, there is a transcript, shall we say, or a file of the Revolutionary Court proceedings. This is obviously critical because it was the Revolutionary Court that sentenced the 148 or so victims. Instead of introducing the whole proceedings, they introduced 4 out of 361 pages. One of the defendants said, the judge, in fact, who presided over this and was one of the accused, says, what do you mean? There's exculpatory evidence in the rest of the file. In fact, that will show that they had, defense lawyers, a key part as to whether these were kangaroo trials or not. The rest of the file was never produced. Harmless error, as Michael Scharf has suggested? Hardly. I mean, how can you call this harmless when, the 357 pages of the 361-page document is never introduced and the defendant claims that there's critical exculpatory evidence in there? Bottom line on all of this, yes, we know Saddam committed terrible crimes. It is sad that today we are sitting here and having to debate the fairness of the trial rather than focusing on the horrendous crimes that Saddam committed. And what makes this particularly sad is that this was avoidable. We could have avoided this by simply accepting the international expertise that is readily available, that has emerged out of Rwanda and Yugoslavia and Sierra Leone, etc. There are many people out there who know how to do these trials well. It could have had a significant Iraqi component similar to the Sierra Leone trial, but ideology prevailed. The Bush administration didn't want to do anything that would legitimize the project of international justice because it hated the International Criminal Court, which of course could theoretically prosecute an American, and therefore it was not going to endorse any international tribunal that might indirectly lend credence to the ICC. It of course also wanted a court that it could largely control, that wouldn't ask the difficult questions about what was the U.S. relationship with Saddam during Dujail? What was the U.S. relationship with Saddam during the Iran-Iraq War? What was the U.S. relationship with Saddam during the Anfal and during its aftermath? Tough questions an independent court might well have allowed to be answered. So ideology, narrow self-interest prevailed, and what we have now is a seriously defective trial that is diverting us from the terrible atrocities that Saddam committed. Thank you.
Starting then for the other side, Professor Scharf.
Thank you, Dean Simson. One of my professors in law school once told me that where one sits often colors where one stands. And in this debate, I think what you're going to find is that worldwide, those who are against the Iraqi High Tribunal and believe that the trial of Saddam Hussein was a sham are the very same people who at the very beginning were against the Iraqi High Tribunal because it had the death penalty, because it wasn't an international criminal court, and because it came after the invasion of Iraq by the United States. I personally was one of those people when I began, but Michael Newton and I have had a lot of chance to work with the Iraqi High Tribunal judges, and I suppose that has made us prone to see things a little bit more sympathetically, and perhaps the truth is somewhere in between. Let me make 6 points today in my 12 minutes. The first point is that on paper, at least, the Iraqi High Tribunal meets all of the standards of due process required by international law. Its statute and rules are modeled after the Yugoslavia Tribunal, the Rwanda Tribunal, and the Permanent International Criminal Court. The protections of due process include the presumption of innocence, the right to be informed of charges, the right to defense counsel, the right to be tried without undue delay, the right to be present during your trial, the right to examine and confront witnesses, the right against self-incrimination, the right not to have silence taken into account in determining guilt, the right to the disclosure of exculpatory evidence and witness statements, the exclusion of coerced evidence, and the right to appeal. Note also, Professor Heller, the Rule 43, which you're complaining of, is word for word the same language of the Yugoslavia Tribunal and Rwanda Tribunal's rules on the exclusion of confidential information that is not used at trial. Now, my second point is one that will be a surprise to many of you. In some ways, the Iraqi High Tribunal is actually more fair than the United States court system. There are three of those. First of all interrogations must be videotaped. So there is a videotaped record of whether there is coercion, something we don't have in the United States. Secondly, the proceedings are broadcast gavel to gavel, ensuring transparency. The reason we know about all of these errors and missteps is because we've gotten to see them on TV. In the United States federal criminal courts, there is no television coverage. And third, there is a written verdict, a detailed verdict that we will see at the end of the month that'll be 300 or so pages long, enumerating all of the very specific findings of facts and conclusions of law, something we don't have in the United States. We just have a jury, a black box, who makes a decision. Sometimes it's juror nullification. We just don't know what the basis of it is. My third point is this. We must assess the Iraqi High Tribunal with an understanding of Iraqi law and process. This is based on the international law principle known as the margin of appreciation. We can't look through American eyes in deciding the fairness of this process. First of all, Professor Heller talks about the standard of proof. He says it's not beyond reasonable doubt, so therefore the whole thing is a wreck. Of course, the proof standard is the same language, basically, of the Dutch. It is the satisfied of guilt. When we talked during the training sessions with the judges and asked them to explain what that means in practice, they used another phrase. They said, we like to convict only when there is proof beyond a moral certainty. This is actually a phrase that most of the civil law countries use. I talked to them more about what that phrase means, and I came away convinced that it is either the functional equivalent or even a tougher standard to meet than our beyond reasonable doubt standard. Also, Professor Heller failed to tell you that our own Supreme Court has never defined what beyond reasonable doubt means, leaving it for every jury to try to guess at this talismanic phrase as if it in itself has some special quality more than requiring what the Iraqi High Tribunal requires. Secondly, Professor Heller complained about the mid-trial confirmation of the indictment. Well, this is actually very similar to what the Yugoslavia Tribunal and the Rwanda Tribunal do when halfway through the trial they entertain motions to dismiss. And literally what the tribunal does at the beginning of the trial is decide whether there is enough evidence to begin, and after the prosecution's case, then they decide whether there's enough evidence to continue. They do give the charges at the beginning of the trial. They give even more specific charges based on the evidence halfway through the trial. This is the way they do it in the Middle East. Are all the Middle Eastern countries, by virtue of the fact that they're different, all flawed? Third, the role of the defendant. In Iraqi law, the defendant gets to ask questions. It's very different than we see in the United States, but it actually increases the level of fairness to allow Saddam to have this opportunity. Fourth, pretrial motions. We heard Mark Ellis earlier today complain that the pretrial motions weren't decided pretrial, and I wish they had been as well. That is the way they do it in the international tribunals. That is not the way they do it in some courts around the world. These pretrial motions will all be addressed in the 300-page opinion, and that is in fact the way they did it at Nuremberg. That's in fact the way they do it in many countries, and there's nothing under international law that says that that is per se a violation. My fourth main issue is that there are unique challenges that this Iraqi High Tribunal faces. We have heard today about the antics of Saddam Hussein. Let me give you some specifics. Every day, Saddam goes into the courtroom with the goal of disrupting his trial, of enticing and inducing the judge into yelling at him so the trial will look unfair. He has called the judge a homosexual, a traitor, a whoremonger. He has insulted his family. He has called him a dog, which in Iraqi is the worst thing you can call somebody. And every once in a while, the judges have lost their temper. Now, in trials in the United States, like the Zacarias Moussaoui trial last summer, when the defendant did the same thing, Moussaoui was thrown out of the courtroom by the U.S. federal judge 4 times in a single day. When that happens in the United States, the professors and the commentators say that was appropriate. Why should it not be appropriate when the same thing happens before the Iraqi High Tribunal? We can even look back at the Bobby Seals incident during the Chicago 7 trial to see what happens when a defendant tries everything possible to try to disrupt a trial. And Bobby Seals, of course, we all know, ended up being gagged and bound. It was not a good moment for American jurisprudence. But sometimes American judges are struggling with the same kinds of problems, and there aren't a lot of options. My fifth point is about harmless error. We heard some preemptive discussion by both my colleagues about that. The documents in the trial, and there were 7 that were authenticated, these 7 are actually posted for you to read on our website, so you can decide for yourself. They're in Arabic with English summaries. They actually prove all the main elements of the crimes against Saddam Hussein. The surprise here was that this was like Nuremberg. Saddam, if he's convicted, will be convicted on the strength of his own documents. The documents show that Saddam Hussein ordered the destruction of the town of Dujail. He ordered the rounding up of the 300 people. He ordered their interrogation. He gave medals of honor to the interrogators who ended up killing 1/3 of these people during interrogation. He ordered them then tried by the Revolutionary Court, and he signed their death certificate. All 148 people tried. That's the record. Those are documents. You know what? Saddam Hussein admitted on March 1st that those documents were true. In his famous statement that my colleague and co-author Greg McNeil refers to as the Jack Nicholson moment from A Few Good Men, Saddam Hussein said, yes, I admit it. I gave those orders, but any president in my situation would have done the same thing. And so this case is really a legal case. It's about one question of law. Is it appropriate for a leader to do what Saddam did? The facts are not in dispute. And ultimately that question of law will be decided first by the trial court, and if that court is for some reason biased because of the yelling matches that have gone on, that same legal issue will be decided by the 9 appeals judges who will not have been biased. Also, and finally, I want to point out that we have seen a lot of misleading press reports about this trial, and I myself have fallen prey to this. 2 weeks ago, I got a call from both the Washington Post and LA Times. They said, did you hear what the president of Iraq just did? I said, no, tell me. They said, the president just reached down and had the judge removed. Both of you have pointed that out. Many of the people today who've talked about that have pointed that out as the biggest problem with this tribunal. And then what did I do? I shamelessly gave a quote. I'll read what the paper in the Washington Post ended up saying. Quote by Michael Scharf. This raises alarm bells, said Michael Scharf, a professor at Case Western Reserve University School of Law and advisor to the tribunal. Quote, it looks like the government is trying to meddle with the tribunal. This will erode the tribunal's independence and legitimacy further in the eyes of the international community and the Iraqi people. And I was worse for the LA Times, I suppose. I said, Professor Michael Scharf, a law professor and war crimes tribunal expert at Case Western Reserve University in Cleveland, said that Amari's dismissal could set a dangerous precedent for executive branch meddling in the judiciary. Well, it wasn't until the next day that I found out what really happened. And this is often the case with the poor Iraqi High Tribunal and the misleading press reports. This is what happened. The prosecutor had requested the removal of the chief judge. The other judges got together and voted unanimously to have him removed. They then had the president of the tribunal make a request to the president of the Iraqi government to have him removed. Not because, what the press reported, he said, Saddam, you're no dictator, but rather because there was a record of 100 or more things that were mismanaging the trial in the first 3 weeks that were driving his colleagues batty. And they just felt that they needed better management. And if I had known that that was the way, I wouldn't have said those things to the press. I would have said that, in fact, this is exactly the way it should be working. So let me conclude like this. The Iraqi High Tribunal must be fair, but we also must be fair in assessing it. The trial was a mess, that is for sure, but the errors and missteps did not create a miscarriage of justice. Thank you.
And last is Professor Newton.
Thank you very much. The intellectual caliber both of these debates and of this group has been impressive, and it's an honor to be here. The famous English poet Ian Hamilton once said that on the day of battle, the truth lies naked on the battlefield. The next morning, she's gotten up and put on her uniform. And I think that's what's going on a lot. The defense strategy of disruption and distortion is really distracted, particularly in light of the Arabic nature of the proceedings, from what's really gone on in the courtroom. And I must say, with great respect to both Human Rights Watch and some of the other trial observers, there's much more, and I know this firsthand, that goes on behind the scenes to ensure a fair trial and a fair process than what you ever see actually in the courtroom. And I think that's important because Article 20 of the Iraqi Constitution says that the right of defense is sacred in all stages of investigation and trial in accordance with law. That's what a fair trial is. It's a trial based on evidence and based on counterargument, based on the law, and based on the presentation of evidence in the courtroom, and that's what you've seen in that courtroom in Iraq. You've seen it in a way that, in fact, contrary to popular perception, has resisted political pressure. People all over Iraq for months have said, why isn't this trial done? Why isn't it moving faster? In fact, in early 2004, after the investigative judge had the first investigative hearing with Saddam, you remember there was lots of political pressure. They said, well, trials are going to begin in the fall. They didn't because the judges weren't ready. The evidence wasn't ready. Trials are beginning in the spring. They didn't. They resisted political pressure at every step along the way. And in fact, today, there's been no demonstrated record of political pressure from outside the process actually affecting what happens in the courtroom. And I think that's critical because the fair trial process has been followed in fact, if not in perception. And the facts here are what matters. That's what this debate is all about. I must point out just in passing that the effort to discredit the process is not a new standard. We've seen that from Milosevic, who called the tribunal a lawless act of political expediency. Let me give you a quote. Here you have the U.S. pressing for a criminal tribunal against its enemies, so that in effect the statute authorizes this process, which is war by another means. You're attacking your enemies by first demolishing them, by telling the world that they're genocidal murderers. I know this is not a press conference in Oman. During the Dujail trial, this is Ramsey Clark in the ICTR context in the Antaki Rudamana case. This is not a new tactic to try to discredit what's going on in the courtroom simply by virtue of deviating from the politics. In fact, it's been the other way around. The judges have striven with great fortitude to try to keep the politics out of the courtroom. Over and over and over again, they have said, this is not a political trial. If you have an evidentiary point to make, please make it. If you have a piece of exculpatory evidence that you want to be obtained, please request it. Keep the politics out. Let's stick to the facts. Let's stick to the law. And in fact, most times when you see Saddam on CNN rampaging, they'll cut it, and what they won't show is what comes next. When the judge says, I'm the judge, you're the defendant, I'm the Iraqi judge applying Iraqi law in accordance with the rules of procedure. Now, if you have a substantive point to make, please make it. That's what a fair trial is all about, folks. It's about evidence, and it's about law. Now, we all know that as was pointed out, one of the critical, fundamental, basic trial rights is the right to have adequate time and facilities for the preparation of the defense. That point has been made today repeatedly. It's been made by our opponents. Despite claims to the contrary, defense counsel have been able to see their clients every single time they request. Sometimes not when they request it. There's been a delay because of transportation and security issues. Sometimes they've been transported in a way that they didn't like, but they've been able to see their clients. They've also been able to exchange documents. During trial, and this is, I don't think, ever been publicly said, but it's true, because I saw it. During trial, they have a secure video link where they can get on the phone and talk in a totally secure way with their clients. So there's plenty of opportunity to both prepare for trial. The point was made about 60-day processing. Yes, the Iraqi rules and the statute require 45 days before trial the referral packet. That was met. In this trial, they got the referral file 60 days before trial, exceeded the standard. Evidence that's discovered during trial is, of course, handed over properly, just like in any other court in the world, to include the ad hoc tribunals. One more point about the preparation of the defense. They've said, well, we didn't have time to prepare. They came to court the first day on October the 19th. We didn't have adequate time to prepare, despite the fact they'd had more time than required by the statute. What did the judges do? Gave them a 38-day delay right off the bat. That happened on 3 subsequent occasions. So that today, of a 12-month trial, over 3.5 months are attributable just to defense requests for more time for preparation. That's the hallmark of a fair trial, of a judge who's bending over backwards to give the defense the adequate time and opportunity. One more point about exculpatory evidence. people have said, well, the entire Dujail file wasn't turned over. The fact is, that's one of the critical questions of fact at trial. There's very powerful evidence that there was, in fact, no trial ever held. There's some small evidence on the other side that there was a trial. There was a request made by the defense for the records of trial that would prove it doesn't exist. So, of course, it wasn't turned over. All the documents related to the Dujail trials themselves were handed over, the ones that were in the possession of the court. I want to make one more point about the conduct of the defense, because I think this is critical. The phrase "daughter of a whore" was referred to. Many insulting things that would have gotten people disbarred from any other court in the world. One day on July the 29th, Saddam stood up and he said, "Down with America, down with the traitor, long live Iraq." Every single defense lawyer stood up and chanted with him. Now, as a prosecutor, I would have been horrified. And any judge that I know would have been horrified and kicked them out of court and quite possibly sanctioned them for contempt of court. That didn't happen in this trial. The judges have bent over backwards to give the defense time after time after time after time to both prepare for trial and participate in a good faith way, which in fact goes to the allegations of bias. In my mind, if there's been any bias here, it's been on the part of the judges, bias towards allowing a fair process, letting them get away with things that they would never get away with in ordinary civil court or in any other court in the world at a domestic level. In fact, they did have the power to hold them in contempt. Very pointed rule, both from the ICT, the substantive rules of procedure, but also from the underlying Iraqi criminal code. I quote, "A judge or a criminal court may impose legal proceedings against counsel if, in its opinion, the counsel's conduct becomes offensive or abusive or demeans the dignity and decorum of the special tribunal or obstructs the proceedings." I would submit to you that every single one of those has happened on the part of the defense multiple times, and it has never been met with the sanction of contempt, precisely because the judges are bending over backwards to let them present a fair trial, to let them engage on the evidence if they choose to do so. The fact that they haven't chosen to do so is not the indictment of the tribunal, it's the indictment of the defense counsel. 2 points to end with. One, there's been a lot of talk about the security environment. There's been widespread claims that the security environment itself affected a fair trial. I would say to you that that's a question of fact for the tribunal. That's a question of legal argument to be made during closing arguments. If in fact there was a legitimate effect of the security environment on the conduct of the defense, that's precisely the kinds of points you document in a written brief that you put into your closing argument. What did the defense do? They boycotted the closing argument. They said, "We're afraid to go to Baghdad." The truth is, and this is a matter of historical record, they were in Baghdad 2 times the same week to consult with their clients. But on the day it comes to go to court, make the closing arguments, document for the historical record the gaps in the defense, the way they think they've been mistreated, the legal effect on the case, which is the critical legal piece here, they refuse to do it. And they have their own reasons for doing that. I'm just saying the fact is that there has been no demonstrable effect of the security environment on the actual conduct of the case. Witnesses were procured. Evidence was procured. I mean, that's what happened. With respect to the deaths of the defense counsel, that's entirely tragic. In my mind, those people died as heroes in defense of the rule of law. However, let me point out, and this is true, also true factually, the first 2 deaths came the first day after the opening of trial. The court was already in a 38-day recess at defense request to prepare for time. Tragedy. But I wouldn't say that having additional time after those deaths to prepare would critically undermine the entire rest of the trial. Yes, there were maybe some consequences on the defense team, and if there had been, they should have come back to court and said, "We need more time." And the demonstrated record is that when they asked for more time, the court granted them more time. The same thing also happened with Khamis Obeidi. The court was already in recess when he was murdered for an extended period of time, allowing defense to prepare its closing arguments. And in fact, we know, objectively, that his death had no real effect on the presentation of the evidence because the defense counsel chose to boycott closing arguments. The fact is, in every single way possible, this court, in enormously complex circumstances, has provided secure transportation to the defense attorneys. They have been over backwards to preserve the right to present evidence, to allow the defense to collect evidence, to gain them access to their clients when appropriate. They've provided secure housing for the defense attorneys during the conduct of trial days. They've done everything they can do, despite the security environment, to ensure that these trials goes off. And at a fundamental level, the court, I believe, made a fundamental decision that said the point of this process is to demonstrate a fair trial, fair process in accordance with international standards. If we simply stop the trial because of the security environment, because of the threats, what we're essentially doing is rewarding those who are waging war against the rule of law. This court made a very courageous stand to uphold the rule of law, to try to conduct a fair trial in extraordinary circumstances. I would end by quoting the Appeals Chamber of the International Criminal Tribunal for the former Yugoslavia. They said, "It's in the interest of justice to include the interest of the international community in a fair and expeditious trial and the effective presentation of evidence." That's what you've seen in that courtroom. You've seen no procedural bars to that. You've seen no systematic bars to that. You've seen no political bars from that. As was said earlier, this is not a sham trial. This is a substantive trial. It's a trial based on evidence. It's a trial based on law. It's a trial based on fact. And that's the historical record that I believe this trial should be remembered for.
We're up now to a rebuttal, and I think we'll have the participants do it from their seat. They'll each get 2 minutes to respond to arguments from the other side, and we'll start with Professor Heller.
2 minutes obviously isn't enough to respond point by point, so I just want to make a few general comments. First, I'm certainly not against the IHT. I certainly don't believe that the trial was a sham, quite the contrary. What I do believe in, however, is the importance of written law as opposed to informal procedure. 50 years from now, 100 years from now, there will be no judges of the High Tribunal to talk to. Even the youthful Michael Scharf will not be here to turn to explain how the trial actually functioned. All you will ultimately look back on with the passage of time is the written law. That is what governs this trial. That is what governs future trials. And Article 4, which gives unreviewable discretion to the executive to remove a judge, maybe it wasn't used without the participation of the tribunal in this particular situation. I don't know. I can't comment on that. I do know, however, that that provision is there. It undermines the already existing provisions that allow the tribunal to police itself. One of the great things about Iraqi law is its positivist basis, is its commitment to strict legality. There is a provision in the Constitution preventing the retroactive application of criminal legislation. And the more that we simply ignore that, I think the weaker the court becomes. And the final point is, and Professor Bassioni has talked about it before, I'm not an uncritical believer in internationalizing everything. I believe countries have the sovereign right to create their own legal systems. I wouldn't have complained if, in fact, this had been an even more Iraqi process. I might have still disagreed with certain points, but I have no problem with that. What I find the most problematic about the IHT is that it's somewhere in between. It wants to incorporate international criminal law in terms of new kinds of crimes, new kinds of liability, different kinds of sentencing considerations. But it doesn't want to incorporate international criminal law when it comes to the protection of the defendant, the procedural guarantees. And that kind of selective incorporation of international criminal law is what I find the most troublesome about the IHT.
Thank you. Next, Mr. Roth.
What's striking to me is how much the defenders of the tribunal ignore the reality of the trial. Nothing about the vague indictment that gave no notice and opportunity to prepare. Nothing about the unnecessary use of 26 anonymous witnesses who couldn't be effectively cross-examined. Nothing about the 29 witnesses who had a written statement turned in, which you couldn't possibly cross-examine. Instead, we get a bunch of straw men. Milosevic discredited the tribunal. So I guess I'm like Milosevic. You know, the Iraq War, people who are against that. What does that have to do with anything here? You know, we want to follow the good rules of the court, but they weren't followed. So let's not cite the rules. Let's look at the reality. Let's look at it through Iraqi eyes. Well, you know, the same eyes that have a 15-minute trial for a 30-year sentence. I don't want to look at it through those eyes. I want a fair trial. The disruption of the defense attorneys and all. Yes, they were disruptive, but none of the problems that I outlined had anything to do with that disruption. They were all the way the judges chose to conduct the trial. Now, where we did try to meet on some of these facts, Michael says 7 of the documents were authenticated. Look on his website. The reality, there was a handwriting expert whose written statement was submitted that couldn't be cross-examined. The defense was not allowed to submit its own handwriting expert to give a contrary point of view, and the defense was not allowed to even look at the original document. It could look at the website, but you can't tell from a website whether something's authentic or not. That is not a fair way to proceed. Another example, Michael Newton says, well, we don't even know if there was a trial in the Revolutionary Court, but we do know that there was a 361-page file which was cherry-picked so that the 4 bad pages were put in, but the 359 allegedly good pages were kept out. I used to be a federal prosecutor. If I did that, I would be disbarred if not prosecuted. Here we're calling it harmless error. This is not the trial we want. These were awful crimes. We should be focusing on the crimes, not on this parody of justice that took place. And we didn't have to be here. Any objective assessment of this would have said we need a Sierra Leone-type situation where it's internationalized, as much national participation as possible. Instead, ideology prevailed, and we went with a national system that wasn't ready for it.
Thank you. Next, Professor Scharf.
Thank you. This week marks the 60th anniversary of the Nuremberg Tribunal's judgment. And on the Faculty of Law at Case Western, we have a former prosecutor from Nuremberg, 87-year-old Henry King, who was 25 during the Nuremberg trial. And he's told me repeatedly, and I've seen the documents myself, about how in the aftermath of Nuremberg, the Supreme Court judges, who were the colleagues of Chief Prosecutor Robert Jackson, said things publicly like the Nuremberg trial was nothing but a high-grade lynching party, that the Nuremberg trial violated so many provisions of fair process that no fair trial in the world, no civilized system would accept its findings. Well, now, 60 years later, we celebrate Nuremberg. And I'm going to make a prediction, which maybe I won't be around to fulfill, but maybe our kids will and my students. I predict that in 60 years, but maybe only in 10 or 20, people will look back at the the Iraqi High Tribunal and also its sister court, the Bosnia Tribunal, which is very similar. They are domestic tribunals that have international elements, their crimes, their rules, and the advisors are international. And they will look back at these tribunals, with all of their flaws, with all of their warts, as launching a new kind of criminal tribunal that is an important supplement to the International Criminal Court and to domestic trials. Thank you.
Thanks. And last, Professor Newton.
Well, the legal phrase is equality of arms, and by sheer happenstance, the trial days ended up split exactly down the middle for both the defense and the prosecution in terms of witnesses, and this is potentially important because it shows the latitude that was given to the defense to present their case, to present their exculpatory evidence. 22 confirmation and government and prosecution witnesses as opposed to 62 defense witnesses. The numbers really don't matter. What matters is the fact that the defense had every chance in the world to present its case, even to the point, and I think this is critically important to remember, after it became obvious that the defendants themselves were going to take every opportunity to disrupt the proceedings, they were still allowed to present exculpatory evidence, to present their opinions, to cross-examine witnesses, a remarkable demonstration of good faith and the effort to present an open and fair trial. I will tell you in closing, one of the most inspiring things I've ever seen in my life as a lawyer was during the day that the appointed defense counsel came to deliver closing arguments. Saddam stood up and he wagged his finger and he said, "If you speak, you're an enemy of the state." These arguments had in fact been prepared by the international advisor, which was pointed out, but then critically they were taken by the Iraqis and changed. They were Iraqi arguments. Saddam stood up and he wagged his finger and he said, "If you speak, you're an enemy of the state," on live TV. That lawyer stood up and spoke for 4 hours. Very substantive, very powerful argument, attacking the evidentiary basis, attacking the forms of participation, attacking all the substantive things that we teach in our law school courses. That's what a fair trial is all about. That's what you've seen in Baghdad.
Okay, thank you. I want to thank all 4 speakers for an incredibly informative and stimulating debate. We're going to just take a very 30-second break to let the speakers catch their breath. Then I will take questions from the audience, and I'll explain that format then. All right, thank you again. We have 15 minutes of time here for questions. What I'd ask people to do when I recognize you is direct your question at one of the participants. So name the individual to whom your question is addressed. After that person speaks, and I'm asking again to have people speak for 2 minutes in answering, I'll then invite someone from the other side to respond similarly in 2 minutes. When you ask a question, too, and I recognize you, as you start to ask it, wait for the microphone. There's a couple of microphones coming here. Wait till it arrives. So, questions? Yes.
To Michael, and I was supporting your view until you misrepresented my quote this morning, but which opened up an interesting issue that you've not answered. You mentioned that I was talking about pretrial motions, which is not what I was speaking at all. I was speaking about the failure of the court to follow its procedural rules with motions in general, and that specifically deals with the issue of bias. Under the rules, the prosecutor or the defense can make an argument that the judge was biased. That must be brought to the appeals court, and that decision from the appeals court must be done in 10 days. 4 months later, after the defense made that motion, the trial judge came back and said, "Oh, by the way, we've had a discussion with the appeals court, and they've decided that I'm not biased," which is exactly what the chief judge said. So it's not a pretrial issue I have, but it is a failure to adhere to the procedural rules on a very important issue of motions, particularly with bias. You didn't answer it. You need to do it.
Sure. All right. The point I was making is that some places around the world, they don't deal with these things pre-trial or even interlocutory during the trial. And Iraq and the Middle East is one of those areas. The Iraqis have layered their own system, their own practice on top of this tribunal. And in some cases, I think it took even the trainers by surprise what the results of that were. This is one of them. I would have hoped that they would follow the precedent of the international tribunals and decide these things as they arise. And in fact, one of the lessons learned that I am promoting is that they do that in the future. But there were a number of motions. There were challenges to the legitimacy of the tribunal, to the bias. Saddam claimed that he was tortured. And I believe that what we're going to see in the 300 or so page judgment is an analysis of all of those. And if that comes out in the judgment, and if we look at this in terms of international standards of fairness, that is fair. And then that can be appealed. And those decisions can be ultimately taken by the appeals chamber.
Either Professor Heller or Mr. Roth, either of you respond to that?
Well, I mean, first of all, I think that didn't answer Mark's question, which was, here there are rules that say that a motion of bias has to be heard, ruled on by the trial court, then appealed within 10 days. It didn't happen. Another case, different setting, which didn't happen, is the challenge to the 29 witness statements that were read in without a right of confrontation. It was just ignored. Now, maybe we'll get an answer to that at the end of the trial, but that's just not a fair way to proceed.
Okay. I'm going to read, there's a question, we'll give representation to the people who are in the other room viewing this. Sarah Nolan asks for Professor Newton to respond. You mentioned the fact that the judge, quote, bent over backwards, end quote, for the defense. By allowing these things to happen, does that not become unfair?
Well, I've tried cases, and it was said earlier this morning that depending on what day and what issue, he's biased for the defense. On the next day and the next issue, he's biased for the prosecution. I would point to Judge Rizgar, who got criticized from both sides, both participants in the trial, and was criticized around other parts of Iraq by people on both sides of the argument. And the point I was making was that, number one, in the interest of a fair trial, they bent over backwards. They gave the defense incredible latitude, far more than many of us expected, far more, frankly, than they ever, I think, intended to in the training sessions. There was a lot of talk about how are we going to keep the trial orderly and courtroom decorum proper. And then when trial started, they were so conscious of the fair trial rights that they gave great latitude, far more latitude than what we expected.
Okay. And Professor Heller or Mr. Roth, either of you?
I just don't accept the view that because you're criticized by both sides, you must be fair. You got to look at the reality. The reality that was these judges weren't bending over backwards. They let this vague indictment in. They let anonymous witnesses in. They let statements in that couldn't be cross-examined. They let cherry-picked documents in. I mean, this wasn't fair in the reality. That's what you got to look at.
Yes.
this question is for you, Mr. Roth. I'm curious. Almost all of your criticisms of the court are that a civil law system, an inquisitorial system, the Egyptian-French system, does not comply with the procedural standards employed in an Anglo-American system. As you said, for example, an Iraqi trial lasts maybe 15 minutes, 30 minutes, and you imply that that's the whole thing. Well, as you know, I'm sure, months may go into the investigative judge receiving testimony, sworn testimony, that is then received by the trial judge as the record. There is no need to call a single witness in an Iraqi trial. These witnesses are testifying before the Iraqi High Tribunal for the television audience, not because that evidence is not already part of the record that has already been provided to the defense attorneys. How can you, in good conscience, make that challenge to the fairness of the Iraqi High Tribunal?
Because you're misconstruing the argument. I understand about dossiers, but under the continental system, you can challenge evidence in the dossier. If you don't think that the witness statement is legitimate, you can ask for the witness to be called. If you think that a document has been cherry-picked, you can ask for the rest of the document. Systematically, the judges have refused to allow that to happen. So it's not the continental system that's on trial, it's the Iraqi version of it.
Okay. Professor Scharf or Professor Newton?
Well, 1.2 is that, in fact, in this trial and in all other Iraqi trials, but particularly in Dujail and Anfal, during the investigative hearings, the defense has a right to counsel. So those hearings are conducted with the defendant there and their counsel there, and that's generally the time when those challenges are made. To say there's no cross-examination, that generally happens at the point of the investigative hearing and not during the open trial and open session. And I still don't think that we've completely addressed the issue, which is the fact that where there are gaps, the defense had plenty of opportunity to make those arguments, both during trial and during their closings.
Yes.
Sorry, I just want to address one point that Michael Scharf raised as a factual matter. Now, Professor Scharf, I don't know what your sources are for your statement concerning the process by which Judge Abdullah al-Amiri was removed. But I can tell you that our researcher has been to the court, spoken to two of the judges on the unfiled trial panel, as well as other government officials, and it corresponds nothing whatsoever to the account that you've just given. Our information is corroborated by more than one source from different arms of the government. The government was absolutely infuriated by the statement by Judge Abdullah al-Amiri. It confronted the president of the Iraqi High Tribunal and said, this judge has to go. The president said, well, if you want that to happen, you have to make it happen. So you do it. And then the government did it. And that's consistent with what the government has said they did. Ali al-Darbar, who is the spokesperson for the government, has said that's what they did. Bassam Rida has said that's what they did. So, I mean, I'm sorry, I just don't understand where you make this factual claim from.
You know, you said earlier that you have all these alternate histories. I suppose this is one of them. I'm intrigued to hear the alternate histories you have about the drafting of the statute as well. But here's where I get this claim. The next morning, I read a number of newspapers, both Middle Eastern and United States newspapers, and I started to see that they were conflicting public accounts. And I started to get very worried about the statements I made. So I gave an email to the people at the Regime Crimes Liaison Office, one in particular who I trust intimately, who I've been working with for several years now, Eric Blinderman. He wouldn't be worried about me invoking his name. And he said, I will get back to you with a detailed account. And he went and investigated, and he gave me that account. You know, you could say that his account was misleading. I doubt it. I'm not sure if your accounts that you've gotten from talking to the people are any better. But really what this shows is that the entire process of trying to look at what's going on in Baghdad from over here in the United States is a very difficult one for all of us. And we have to be cautious and careful about indicting an entire system based on these misleading and snippets of news that we get out.
And if I could just clarify, the account that my colleague Nehal Boutai just gave was one collected in Baghdad by our native Arabic-speaking researcher, Hania Mufti. So this is not, you know, trying to piece it together from press reports in the United States.
Any other questions? Yes, in the back.
Yes, thank you. If the judge relies upon some of the matters referred to by Mr. Roth in its judgment in this case, would you, since you didn't previously respond with specificity to the problems that Professor Roth outlined, would you consider then that there was some perhaps deficiency in the final result of the trial? Either one of the two might.
Well, yeah, I mean, what I'll say is, in the civil law system, for an example, where we have an exclusionary rule in the United States, and it means that the jury can't see the evidence that is supposed to be excluded. In the civil law system where they only have judges, the way they deal with that is that the judges are not allowed to refer and actually base their decision on evidence that's excludable, and in this case, evidence for whatever other reason is inappropriate. So if in the final judgment that comes out, people can show that there was actual reliance on inappropriate evidence, that's what needs to then be appealed to the 9-member appeals chamber. It's a question of law. And if the 9-member appeals chamber still gets it wrong, then we can have another debate today, or at that point, and see whether the entire process was wrong. But it's premature now, I think, to decide that issue.
Let me just add one 10-second legal clarification, too, which is this, to say that the judges are keenly conscious of their responsibility to produce a detailed written opinion justifying the reasons for that. The statute actually requires them, and the rules of procedure, to take an issue. Maybe it was an cross-examined statement, but it requires them, for everything they consider, to describe the indicia of reliability. In other words, why did they find it suitable to rely on? And that I think, will be a part of the legal justification, which we can maybe disagree with in practice. But the point is, as a fundamental practice, they're going to go out of their way to justify that. At least that's what they're supposed to do.
Professor Heller?
Yeah, I just wanted to add, kind of from a comparative standpoint, that it's very dangerous to keep just invoking the civil law or the non-adversarial systems. They are very different, and Iraq has many advantages over some others and has some weaknesses. And there are very, very few civil law systems in the world today that continue to allow all of an investigative dossier to qualify as substantive evidence. The Russians have recently eliminated that. The Italians have. The Spanish have. There is a much, much more, quote, adversarial element to the civil law system now, where you do not let evidence into the judge's decision that isn't openly discussed in trial. In Russia, which is closest to an uncritical acceptance of the dossier, the jurors that they have in the system now are not allowed to see those parts of the dossier that the judge at trial rules inadmissible for their consideration. There is a much more specific point-by-point analysis of the evidence that is collected by the investigative judge that the Iraqi system, and not saying it's better or worse necessarily, is not the same as. So to defend the Iraqi system by simply saying, well, this is what civil law countries do, I think is extremely inaccurate.
Okay, one final question. Yes, right here.
I have a question for Professor Scharf. If you were accused of a serious crime, would you prefer to be tried in Iraq or in the United States?
You know what? I have to say, depending on my race, depending on where I was, there are places in the United States I'd be pretty nervous about being tried. And I say that because I want us all to remember that our system ain't perfect either. Thank you.
Any further comment? Well, thank you for your questions. Thank you for coming, and thank the speakers. Yeah.